filing order 10 rule 10 में with section 51 we have filed petition with वकालतनामा। इस सब को दिया जिसका
सबका लीगल ईयर्स का वकालतनामा है।
सब कुछ तो दिया देखिए इतना जितना है वो सब कुछ को वकालत
नहीं हम अपने रिकॉर्ड से देखेंगे। दिखाइए जरा बे सबका वकालतनामा कहाँ है।
नंबर 1 मेन
बताइए कहाँ है आपका वकालतनामा रेस्पोंडेंट नंबर 1 के लीगल ईयर्स का।
नहीं
आइए नंबर
है 2944
लाइक
रेस्पोंडेंट नंबर 1
FA number 43 of 2018. Also for the parties are present, the learned counsel for the respondents
I have 2944
has submitted that
2020
the legal years and successors of respondent number 1, 3, 9, 13, 16, 34 and 52 which have been substituted, who have been substituted by this court by the order dated 23/6/2022 have already entered appearance by filing wakalatnama along with the connected interlocutory application filed by the by them before this court office to check and prepare appropriate orders. आप तो बताएंगे नहीं हम ऑफिस बैठ के चेक करेंगे।
अब तो वाला ऑर्डर सब कोई को है मतलब देयर इज ऑर्डर नंबर 16 by this coordinate bench
क्या है
ऑर्डर नंबर 16
क्या है इसमें
सारा डिटेल्स मतलब डेट आई हैव इंटिमेटिंग डेट ऑफ रेस्पोंडेंट नो 1 मंगल दनोरा appellants have filed 3 contradictory IA petition that is praying for substitution of the legal errors of this disease respondent number 1 IA number 10 17 of 21 praying therein to set aside the abatement and IA number 10 18 of 21
ये तो अपीलांट का ना ये है
appellant है तो लोग बोलते abate हो गया कुछ केस में मतलब आफ्टर
आप अभी बोले ना डिसीज रेस्पोंडेंट का लीगल ईयर्स का वकालतनामा फाइल हो गया है ना
सब कुछ
चेक करने दीजिए हम एक भी तो वकालतनामा हमको दिखाइए जस्ट सैंपल आपका रिकॉर्ड से नहीं चलेगा मैडम
अच्छा इधर होगा तो आपको
इधर होगा तो दिखाइए
अच्छा मतलब देखिए आपको देखिए
आइए नंबर बताइए जिसमें वकालतनामा का
रेस्पोंडेंट नंबर 3 का है 11449
लाइए जरा 11449
आइए नंबर 11449 ऑफ 19 रेस्पोंडेंट नंबर 3 का तरफ से 449
हाँ 11447
9 of 447
11447
11447 respondent number
13
एक भी दिखा दीजिए कोई भी दिखा है क्या साथ में वकालतनामा ट्रायल कोर्ट के जजमेंट का डेट बताइए। अवार्ड का डेट बताइए।
5/4/12 का अवार्ड डेटेड 5/4/12 in the arbitration case number 3 of 2010.
इनका अबेटमेंट वगैरह सब सेटिस्फाइड हो
सब
गया।
कुछ हो गया।
उसको चेक करने दीजिए, ये सब चेक करने का काम हमारा नहीं है।
देखिए हमारे 12 का अवार्ड है, अभी हो गया 2025, 13 साल हो गया।
इसके लिए हम लोग नहीं रिस्पॉन्सिबल।
ये तो है आवेदन लोग के, इसको पैसा पड़ा हुआ है लेकिन ये लोग कुछ पेमेंट ही नहीं कर रहे हैं। इतना गरीब लोग हैं।
तो हम क्या करेंगे?
ना,
आपका
आपको-
ऑफिस नोट ऐसा है, आप लोग का एक एक वकालतनामा चेक करना मेरा काम नहीं
नहीं
है।
मैडम, इसलिए अब सब कोई को गलत नोट डाला है, कैसे भी फाइनल बोले सुबह ना तो सब को डाला हुआ मैंने।
आप किसका कौन सा आइए नंबर है बताइए।
आइए तो मैं आपको देखिए मैडम, आइए रेस्पोंडेंट नंबर
1 का आइए नंबर बताइए।
2944 of 2020।
20 उन्हीं लोग को चेक कर लीजिए मैडम।
हाँ, मालूम।
नेक्स्ट वेडनेसडे।
सब वकालत में डाले हुए थे मैडम, जब बोले ना हम लोग क्योंकि सब तो वकालत में डाले हम लोग।
हाँ तो हमारा ऑफिस नोट तो नहीं देखा ना
ऑफिस
उसमें।
है बोले
For hearing and order 41 were alone. Item 16, second appeal 4 of 2019.
This appeal made by the defendants, appellants against the judgment of the farmers. First of all, my lord, I will permit it to point out in the trial court note, it is alleged that the notices, in spite of service of notice, no defendant could appear and file written statement. So the judgment was ex parte judgment. It could have been, but your lordship will find the trial court judgment, after narrating the case of the plaintiffs and the evidences adduced, oral and documentary, no issue has been
Need not be when the matter
Not
is ex
required.
parte.
But still, as per the case of the plaintiff, your lordship requires. I am just placing only the case of the plaintiff as narrated in the trial court judgment. Then I will come to the appellate court judgment.
Yes.
Your lordship, you can see the admission need not require any evidence. Now, admitted case of the plaintiff, your lordship may kindly see page
Let us see.
34. Page 34 is the trial court judgment.
Yes.
It is a suit for without declaration of right, suit for restoration of possession over the Schedule 3 lands as described in the claim by evicting the defendant therefrom through process of law, and to pass order against the defendant to take away their materials of their respective house from Schedule 3. Now, your lordship, just see paragraph 2. Towards middle, just
अब पूरा पढ़िए ना।
Pura. The case of the plaintiff as stated in the plaint is that the plaintiff had purchased 67 decimal of land through registered sale deed dated 15/6/1964. Another 67 decimal of land by registered sale deed dated 26/3/1968. Total 1.34 acres of land out of 2.31 acres of land of plot number 467 appertaining to Khata number 29 Moja Kopa such and such from its owner, namely Wazir Mian, who was the vendor, who was son of Safdar Ali Mian, the recorded Rayat of Khata number 29 and came in possession thereof. The details of both the plots are fully described in item number 1 and 2 respectively of Schedule 1 of the plan. After the purchase of the aforesaid land, the plaintiff amalgamated both the purchased land 1.34 acres and gave one set to the land and came in possession thereof. The aforesaid purchase land was mutated in the name of the plaintiff who has been paying rent to the same to the government. The further case of the plaintiff is that in the minor survey which was held in the year 1961-62, 1.34 acres of plaintiff's purchased land of plot number 467 converted into two new plots bearing number 776 and 781, area 74 decimal and 60 decimal respectively, under Khata number 9, which has been more fully described in Schedule 2 of the plan. Further case of the plaintiff, this is very important. Further case of the plaintiff is that plaintiff put boundary wall in the 1987 around Schedule 1 land and taking protection of police force by order dated 8/3/1987 passed in this case number such and such SDM Hazaribagh. The defendants number 1, 6, 8, 10, 12 and 14 without any right and title committed overtact along with the other defendants by claiming their title and possession in different portion of Schedule 1 of the 2 land on 10/4/2005, for which the plaintiff and his brother Mohammad Riyaz approached Buju of OP police on the police report a proceeding under section 144 CRPC was drawn up in the court of SDM Ramgarh Bhait case number 40/2005. The learned SDM Ramgarh Bhait order dated 28/6/2005 vacated the rule in favor of the plaintiff, making the same absolute against the defendant number 1 to 6. Second part. It is further stated that vendor of the plaintiff, namely Wazir Mia, again sold 1.25 acres of land out of Schedule 2 land to defendant Jafar Mia by virtue of registered sale deed dated 6/1/1985. Whereas Wazir Mia had already sold Schedule 2 land long back to the plaintiff in the year 1964-66-8, and as such the subsequent purchaser of the land would not come in possession 1.25 acres of Schedule 2 land. Thereafter, all the defendants on 25/2/2006 forcibly entered into different portion of Schedule 1 of the 2 land of the plaintiffs, which has been fully described in item number 1 to 8 of Schedule 3 of the plan, and started construction of house and put tiles and asbestos sheet on roof in spite of objection put by the plaintiff. And in this way, some of them completed the house on 27/2/2006. As per the case of the plaintiff, the defendants named column 1 have been construction over the plot given in column 2, area given in column 3 as mentioned against his or their name in table below. So this is the tabular chart where which defendant has acquired land and possession as well as they have constructed their house on which area, that has been described in 2005 and 6 in between on the basis of purchase in 1985. Further case of the plaintiff is that the land of Schedule 3 belonging to the plaintiff who applied for measurement of that case, the Anchal office measurement case number 61/2005-6 got measured Schedule 3 land through Anchal Amin, and the Anchal Amin submitted measurement report annexed with map. The plaintiff requested the defendants to take away their materials used in the said house and go away from Schedule 3 land, but they did not pay heed. Lastly, on 22/3/2010, they refused to do so, which necessitated to file the present suit. So my humble submission for Lordship would be, as per the case, I am not opening my mouth with regard to the defendant's case because defendants were not there. Now, my Lordship will kindly see for a moment. The suit was brought on 20th July 2010 in respect of a cause of action which, according to the plaintiff, without adding or subtracting any word therefrom as per the pleadings, that is on purchased by the defendant through the same vendor illegally even, that is on 6/1/1985, page 35, the last sentence. 6/1/1985, bid number 14317. So after purchase, number the construction according to the plaintiff's case, it is in between 2005 and 2006. That is, my lord, 25 to 2006 and 27 to 2006 completion of their project. So, my lord, if they have constructed their house and they are in possession, and therefore, my lord, all steps have been taken. Now, my lord, my humble submission before lordship would be, the main vital issue would have been, as per the case of the plaintiff. Number one, whether the suit was brought within the period of limitation. Number two, when a sale deed which was subsequently, I accept, subsequently executed in favor of the defendant for the same area in 1985. I can understand that he was not aware about the sale deed, but he could know from 2005 itself. In 2006, then the suit was brought under Article 58 of the Limitation Act, and it is not when the right to sue first accrues. If I accept the date according to the plaintiff's case, that it is only on 25 to 2006 when they completed their house, then it is not within 3 years, it is beyond 3 years. So it was obviously and apparently, as per the case of the plaintiff, it was hopelessly barred by law of limitation. Number one. Number two, if your lordship may kindly see, it has been brought to the judicial notice of the court by the plaintiff, according to his own case, that in 1985 there was a sale deed. But can the plaintiff be allowed to declare the said sale deed to be void because it was subsequently executed in absence of any declaration under the suit, declaratory suit, declaring the said sale deed to be null and void? No such declaration has been sought for, nor it was granted by both the courts. In absence of such declaration, whether the possession of the defendants, as per the plaintiff's case, would have been said to be illegal, and they would be asked to deliver possession in a suit brought after beyond the period of limitation. Third question may be, that whether the learned court below, on the face of the pleadings, would have framed the issues as required under Order 14 of the Civil Procedure Code before recording any finding. And fourthly, my lord, your lordship may kindly see, admits according to section 58 of the Indian Evidence Act, the facts admitted
You see,
need not be.
specific issues need not be framed, but the court has examined. But so far as the point of limitation is
No
concerned, the court
discussion.
has not
Not discussed at all. Even both the courts.
That was their duty under section 3 of the limitation.
Yes, that is my submission. So hopelessly barred by limitation, and that has at least should have been discussed.
Where is your question of law?
Now, there are the limitation. You will also find it at question number G, substantial question number, serial number G. At page 7.
एडवर्स पोजीशन का तो कहानी नहीं
नहीं
होगा,
एडवर्स नहीं, हम तो
लेकिन लिमिटेशन सेक्शन 3
नहीं एडवर्स पोजीशन हो ही नहीं सकता है, कारण हम उन्हीं के केस के मुताबिक आई वाज ऑन द बेसिस ऑफ a registered sale deed,
देखिए जरा
and that is E also important not in this
जस्ट
case.
अ मोमेंट essay number 4 of 2019
I am preparing for the contesting the defendant.
contesting मतलब
One, respondent number
और बाकी
one. If your
बाकी
The
कौन?
notices have been accepted.
Baki, they are the they are cited.
It has been recorded by lordship in previous order, that is 9th of April 2025. The notices have been accepted.
Those parties
as well.
are the of their
their notice is accepted as valid,
Yes.
right?
Yes. In
और
his
इसे
presence.
substantial question of law भी नहीं frame हुआ,
No.
नहीं?
with permission of your ADC.
और भी आपको क्या सुनिए?
Order 41 Rule 11 does not.
Maybe you don't have a locus.
Yes.
Yes, but that is why I am
Any date
seeking
may be
permission
fixed.
if your
नहीं, इतना ही परमिशन आपको दे सकते हैं कि दोनों ऑर्डर में लिमिटेशन का ही कंसीडर किया है।
since the prayer was not made to declaring the same deed as a void, so question of limitation doesn't arise, as because the prayer was made to recovery of possession, and for that purpose limitation was 12 years. That is why the court.
तो ये तो इशू तो डिसाइड
Which
करना
really
पड़ेगा ना।
So
But
it
both
is-
the courts have not
It is
considered it.
misconceived to say that the limitation was 3 years.
We will see, we will hear you. रिकॉर्ड आ गया?
नहीं,
नहीं वो तो जब तक एडमिट नहीं होगा तो नहीं होगा।
रिकॉर्ड मंगा लेते हैं। अभी आपको सुनने का कोई काम नहीं है. Limitation as such has not been considered. We'll just record his submission that at best the case of the plaintiff, the cause of action arose on 25/2/2006.
But these until and unless any pleading is filed on their behalf,
No pleading.
There
No,
is
it is the
absolutely
duty of
no
the court to check the limitation.
there is no pleading at all, as because they have not appeared. The trial
No, no, they are referring to your own case.
I am not.
We will see ना आपका जो case आएगा record आएगा. We will see that what is the date
But,
of cause of action.
The
what have you
limitation
taken?
starts from the date when the cause of action arose in the year 2006, and then, subsequently within 12 years it was back. So my son.
So according to you, it will be governed by 12 years. कौन सा article से governed होगा? Article?
Article to exact नहीं बताएंगे, but I know that it is 12 years. From
But
the
in absence of
हाँ, you know but I do not know. Like अभी हमको नहीं पता जब तक हम
you
exact article I don't
Limitation
know, but
अभी आपका कोई लोकस नहीं.
हाँ ठीक है, वो तो हम
65 over. I am assisting over.
for recovery of police.
But here it is a couple with this cell deed. It cannot be presumed that the cell deed of 1985 was illegal. That is a presumption on the part of the plaintiff. And unless the cell deed is declared to be void ab initio, the possession cannot be said to be illegal. Therefore, E and F.
आपका essay number 4 of 2019. Heard the learned counsel appearing on behalf of the appellant. The learned counsel for the appellant submits that the judgment passed by the learned trial court was ex parte, but on the face of the case put forth by the plaintiff, the suit was barred by limitation. He submits that with respect to the same property, there was a subsequent sale deed which was dated 6/1/1985, right?
Yes, ma'am. Section 34 bars this in
And
this view of it.
and in limitation पर ही करेंगे. 6/1/1985 and at best the cause of action arose on 25/2/2006 when the defendant, as per the plaintiff, had constructed the structure over the suit houses over the suit property. He submits that the suit was filed on
Filed on 20th July
27/2010.
2010.
And even if best case of the defendant is taken into consideration, of the plaintiff is taken into consideration, the suit was barred. He has referred to Article
Article 58
58 of the
and
Limitation
59.
Act.
58. 58 and 59.
58 and 59 of the Limitation Act, and also referred to Section 3 of the Limitation Act,
Yeah.
which cast a duty upon the court to see as to whether the suit is within the prescribed period of limitation under the Act of 1963. The learned counsel has submitted that it was for the court to examine as to whether the suit was barred by limitation or not,
Maintainable.
and therefore the suit itself was maintained. He has placed both the judgments. He has placed the judgments passed by the learned court and has submitted that this aspect of the matter has been completely ignored by both the courts. He has referred to the substantial question of law number
E and G. E related to Milord the in absence of any declaration the our sale deed is illegal. Then our possession is also illegal.
नहीं खाली limitation पे frame करें. He has referred to substantial question of law number G and has submitted that a point has been raised with regard to limitation. Considering the aforesaid submissions, this appeal is admitted for hearing on following substantial question of law. Whether the suit filed by the plaintiff was barred by limitation. Question.
The Lordship may see Milord section 34 of the specific
May I-
related exclusive
may I submit-
declaration in absence of any declaration the possession cannot be claimed
Subsequent sale deed का declaration का भी कोई जरूरत
Milord,
नहीं.
may I
If there
sub-
is a subsequent
with re-
sale deed in
according to
connection,
their own case.
Milord,
Need not.
may I submit one
No,
thing?
unless-
In para Milord 9 of the Milord appellate court judgment, it has been Milord the question has been formulated with regard to that with legality or illegality of that Milord sale deed.
Sale, that is my submission.
So in
If-
para 9 Milord it has been point has been formulated by
I see
the
that.
para 9.
कोई बात नहीं, आप अपना record call for करते हैं.
हाँ, ठीक.
Let the records be called for from the concerned court. The respondent number 1 has contesting respondent number 1
Plaintiff
representing the plaintiff has already entered appearance and he is present in the court. बाकी
They are the
respondents
defendants.
बाकी नहीं के साइड का सब
Plaintiff आपकी अकेले हैं.
नहीं हम प्लेंटिफ अकेले थे बाकी
Plaintiff they are the performer respondent.
rest are
so far as the other respondents are concerned, they are pro forma respondents. उनको दोबारा नोटिस जाएगा क्या? क्योंकि आईए में ही खाली नोटिस गया था कि मेन अपील में भी नोटिस गया.
नहीं
आइए में ही गया.
उनको जाना
आइए
चाहिए
में.
क्योंकि
नोटिस जाएगा ना.
वो परफॉर्मर नहीं थे वो भी प्रॉपर्टी पर
एक तो अबेट कर गया है. As per the records, the respondent number 7 has already expired, and by the order dated 18/7/24,
Yes.
the proceeding has abated as against respondent number 7. 18/7/24.
In that respect, we have already filed an application that is IA number 7758 of 2024.
Pending है क्या?
मेरे ख्याल से disposal to declare pending है. IA
कोई
number
आइए pending है.
7758.
आइए pending है.
एक आइए इस केस में एक आइए 439 of 2023.
Because respondent number 8 being the legal heir, he is already on record. So a prayer has been made to delete his name. Respondent number 7.
वो तो 775 एक डिले के लिए डिले करने हाँ
7758.
आइए नंबर क्या बताया आप?
775
एक बात आप प्लीज कुछ बताइए. हाँ बताइए.
हमको मेरा
आइए नंबर बताइए आप.
7758.
7758 कहाँ है यहाँ पे आइए? ऑफ 2000
24 ऑर्डर हुआ उधर 18 साल का उसके बाद हम
ऑफिस जो है ना ऐसे ही क्या करता है.
आफ्टर द ऑर्डर पास बाय
वो
दिस
डिस्पोजल हो गया आइए.
जो वाली बोल रहा
वो क्या सेटिंग असाइड वो डिलीट करने का ऑर्डर था क्या?
डिलीट का हां उसमें प्रेयर था टू डिलीट द नेम ऑफ द रेस्पोंडेंट
7758
77 गलत नंबर
775/19 was for.
कब डिस्पोजल हुआ है वो? ये डिस्पोजल है आइए
तो
या ये
ये
disposal
डिस्पोजल है।
ये तो डिले का डोनेशन है 7758
19 का 7758 ऑफ
ये तो
19
लिमिटेशन है ये
अब वो ये डिस्पोज ऑफ हो चुका है, इनका तो अलावा हो चुका है।
2024 लिखा
नहीं हुआ।
है।
आप तो
आप नहीं कोई फाइल किए हैं सेटिंग असाइड अपॉइंटमेंट या
Maybe, I'm sorry, but in my record it is 24. And office copy is noted.
या अपने रिकॉर्ड से
और तो
आप नहीं
आए
चल
नहीं।
सकते ना अबेटेड लिखा
हाँ।
हुआ है इसमें तो क्या बोलेंगे
Abated order के बाद हम ये पता नहीं। Sorry.
कोई आईए नंबर है कुछ तो होगा ना मिस्टर सानी आपको कुछ ही नहीं पता है
I'm sorry not for that.
फिर बोलिएगा कोर्ट नहीं देखता है कोर्ट क्या देखेगा इसमें?
Misled by my clerk. That can I say.
ना सीनियर आपका क्लर्क है सर
एक और नोटिस पीरियड हुआ है। डबल टू टू टू
नहीं है इसमें
अभी सिर्फ एक आइए पेंडिंग है उधर इनका इंजंक्शन।
That I will examine. Let it be recorded blood. It was abated blood by daughter.
आप लिख देते हैं ठीक है लेट नोटिस बी इशू टू द रेस्पोंडेंट नंबर 228 for which requisite under ordinary process be filed within the period of 1 week. Let the records be called for from the concerned court. 2 to 6 and 8 है ना
2 to 6
respond
and
number
8.
7 already abated
Within 10 days. No?
within 10 days. Right. Respondent number 1 has already appeared, no notice needed. Choose. Eleven.
Item 17, second appeal 63 of 2020.
सीनियर एडवोकेट महेश तिवारी अपने बिजनेस में आए थे लेकिन तबीयत खराब होने की वजह से चले गए। लॉर्डशिप में एक फाइल को गोल किया लेकिन अंडरस्टैंडिंग थोड़ा कमी है तो अगर लॉर्डशिप की अगर मर्जी फिर भी हाउएवर सब्सटेंशियल क्वेश्चन ऑफ लॉ 3 to 6 इज द सब्सटेंशियल क्वेश्चन।
आप अभी गो थ्रू नहीं किए हैं आपको कुछ पता नहीं है सब्सटेंशियल क्वेश्चन ऑफ लॉ 226 ने आपके कहने पर हम एडमिट कर लेंगे
नहीं
फिर क्या करेंगे
दैट्स व्हाई
हैज ही लेफ्ट द कोर्ट आर यू श्योर और ही इज आर्ग्यूइंग इन सम अदर कोर्ट
नो अस्योर ही लेफ्ट द कोर्ट दैट्स द
तो कुछ तो बता के गए होंगे ना कब के लिए रखा
नेक्स्ट वीक या एनी डे
Okay, second appeal number 63 of 2020. नाम बताइए अपना.
MD Nasim Akhtar.
लिख के देंगे please. The learned counsel for the applicant has submitted that this case has to be argued by Mr. Mahesh Tiwari, who, on account of his ill health, has left the court. He seeks adjournment. Let this matter be posted on 2nd of January 2026. Next.
Item 18, second appeal 11 of 2023.
Who will argue? Who will argue?
Mr. Rahul,
He is in which court?
I'm not aware of the phone number.
You are not aware of
One
the
lakh, 1 lakh something.
Item 19, second appeal 42 of 2023.
This appeal.
Against the order dated 16/1/23, by which the judgment of the court below, lower court below, has been set aside and appeal has been allowed. Happened that the plaintiff, who is
Who are
the
you? You are the suit was decreed or dismissed?
suit was decreed in my favor. Appeal was through appeal, the suit order was set aside.
You are the plaintiff applicant.
And
You are the plaintiff
and the defendant
or the defendant. The suit was decreed.
decree. Plaintiff is the Ilyas Ansari. I am Zubeda Khatun. I was defendant before the trial court, and the plaintiff became the appellant before the lower appellate court. So what happened that the appeal has been, the suit has been filed by the plaintiff for granting of permanent injunction against the suit landlord, that is plot number 127 and plot number 532, khata number 127 of area 80 square feet. The case of the plaintiff is that he has purchased the land from one Raj Kishore Prasad, who is son of Kamala Devi, and during the span of time, some portion of the land where there was copper post makan, that was demolished, and he wanted to reconstruct that copper post portion of the land. In the case of the the supplement is not allowed to, the supplement does not allow to construct the copper post, stating that this is her land. So the case is that suit land is khata number 127, but the plot where the copper post structure was there, that was khata number 229. Both are separate. and the learned lower court has also found the same, and on that basis the suit was dismissed. But the appellate court has not taken this aspect into consideration.
Where is the finding of the learned trial court?
The trial court finding is starts from
Where is this finding that the construction is on
Yes,
some other point?
Start from page 17, running page 17.
Yes, you tell us where is that finding?
It starts from here itself.
Yes.
हम
As per the evidence.
पेज 18 at the top में top देखा जाए इसमें फाइंडिंग है जिसे फाइंडिंग प्लॉट नंबर 229 खाता नंबर 532 यहाँ से स्टार्ट
हाँ,
है उसके पहले से थोड़ा सा आ रहा है the plaintiff and his witness has stated that property being plot number 532 खाता number 127 the defendants are obstructing the peaceful possession of plaintiff defendant in its plea have adduced 7 witnesses defendant has the lead showing the plot number 29, khata number 532, all the defense witnesses have stated that the disputed property being khata number 229, plot number 532, is owned by one Durga Sardar. The said property was leased out by the defendants, leased out to the defendants for a yearly rent, and the defendants are the leasee of the said property. The plaintiff have no right possession over the property. One pertinent fact to be drawn at this point is that plaintiff is seeking injunction for plot number 532, khata number 127. Plaintiff has filed documents related to plot number 532, khata number 127. However, the defendants are claiming right over the plot number 229. There is a distinction. Khata number 532. Defendant witness have also stated that they are not aware about the plot number 532, khata number 127. So these has come later on also. And number 2 issues. Number 4 has been framed, vendor and non-vendor of party. That issue has been decided, but that issue has not been taken into consideration by the lower appellate court, and it has not been decided. So khata number is different. So trial court has found that khata number is this difference. There is no dispute over the khata number.
Yes. What happened in the appellate court?
Appellate court has set aside this order.
Where is the finding of the appellate court? Finding of the appellate court. Where is the point of determination by appellate court?
Appellate court has gone on a different point of view. It starts from page 34, section 58 of the Indian Evidence Act. ये last 4-5 lines of page 34.
First you come to the point of determination, para number 11.
Point of view,
Determination, para number 11
para number 11 of the suit, of the trial court.
of the appellate court.
Appellate court. Fine. On the basis of the memo of appeal, grounds of argument by the learned court, counsel for the appellant and respondents following points emerged the determination in this appeal. Whether the plaintiff appellant is entitled to get permanent injunction over the property mentioned in schedule complaint, whether the findings of the learned lower court is sustainable or not. So it has come whether the permanent injunction, prayer of permanent injunction is can be granted or not. This question has been formulated. But here the question could have been formulated that whether the suit property by the plaintiff and whether the claim property by the defendant are the same or not. They are not the same exactly. Since they are adjacent and proposed portion was dilapidated, so thereafter they wanted to grab the property of the defendant, saying that is part of plot number, khata number 127. And Durga Sardar, who is the owner of khata number 229, has deposed before the court below, and she has stated that plot number 229 has been given on lease to the defendant. So both properties are separated. There would have been no dispute. But dispute has been arose for grabbing of the couple post portion of also, in which the defendants are residing, and a couple post portion was there on the land of Durga Sardar. And plot number 127, the land of plaintiff, are not of the Durga Sardar. It was a land of Rajkishore Prasad, son of Hanuman Prasad. Appellate court finding have gone to a separate direction, my lord, on the maintainability of the ingredients of the granting permanent injunction, etc., etc. Has to be decided. It would have been decided on the basis of as to whether the khata number 127.
You see, the appellate court has recorded a finding that both the parties are claiming different property,
Yes,
and
that's
therefore
fine.
there is no cause of action.
That's true. Then there will have no question of appeal, my lord.
No, the plaintiff had filed the appeal, correct?
Because
The suit was dismissed.
because suit was dismissed, nahi, because appeal was allowed.
No.
Suit was dismissed in my favor.
That's right. The plaintiff then filed the first appeal, no?
First appeal.
Plaintiff filed the first appeal because the suit was dismissed.
Because the suit was dismissed, the plaintiff has filed. Plaintiff has not filed first appeal. Yes, plaintiff has. So I'm defendant. Plaintiff has filed
Plaintiff filed the first appeal.
first appeal.
But in spite of giving a finding that these two properties are different, still the appellate court has allowed the appeal.
Allowed the appeal. That is my submission.
आप जरा ये बताइए पेज नंबर 37 पेज नंबर 37
Yes. Whether the finding
internal page 15 the plaintiff sought relief for permanent injunction.
page number 37.
Internal page 15 of the appellate court.
Internal page 15.
Yes, the plaintiff sought relief. पढ़िए.
The plaintiff sought relief for permanent injunction over khata number 127, plot number 532, which is not disputed by the defendants, and the plaintiff has show his prima facie right, title and position over the suit land by producing registered sale deed and municipal tax receipts. There is no overlapping of interest between the plaintiff and the defendant, and the DW has deposed that they have no objection on khata number 127, plot number 532. But defendant number 1 has obstructed the plaintiff appellants in construction over the suit land. The defendant number 1 has not filed any counterclaim over the suit land, and she has filed a khatiyan of khata number 229. That is my case, my lord.
Yes. So therefore, the plaintiff was seeking a declaration only with respect to khata number 127, plot number 530.
That's
You have no objection. So you have been restrained from disturbing the plaintiff.
But the proposed portion which was constructed there was on khata number 229, and it was adjacent to khata number 127. So,
Where is the finding that the cupboard post was on khata number 220?
this is the submission of the party.
Submission से नहीं चलेगा ना?
नहीं वो तो आया.
You see, सीधा सीधी एकदम the plaintiff is claiming property injunction over with respect to khata number 127, plot number 532. Defendant has no right, title, interest and possession with respect to
Even
that
no objection
property.
regarding that.
No objection regarding
that.
Now there is no objection regarding that.
No objection.
Therefore, under such circumstances, if the suit is decreed with respect to khata number 127, plot number 532, you should not be having any objection.
but it has been mixed Miller.
Mixed with what?
127 with 229. It has
No,
been
it has
mixed,
not been mixed.
mixed by the
No. No. The defendant has not filed any counterclaim and has filed Khatiyan of 229 plot number C, which is a different plot. The obstruction created by defendant number 1 to cause damage to the plaintiff's appellant, which cannot be compensated in terms of money. The injunction is necessary at this stage to avoid multiple
this the purpose of
You
both the
see,
parties.
when the property claimed by the plaintiff and the defendant are admittedly different properties,
Yes.
then under such circumstances, if there is any kind of obstruction or any kind of disturbance created by the defendant with respect to the property of the plaintiff, so he has to be injuncted.
It's not case that I have created any problem to him. The
So,
case,
if you have not created any problem to him with respect to the suit property, then what is your objection regarding injunction?
because they are both the lands were adjacent to each other. Either since Copper Coast had demolished, so they are trying to grab that Copper Coast portion.
You see, that would be a
demarcation would
separate.
have been, the purpose would have been solved if there is demarcation.
Go for demarcation. उसके लिए क्या आपको किसमें क्या करना है? उनका प्रॉपर्टी, उनका राइट इज ओनली इन कनेक्शन विद खाता नंबर 127 प्लॉट नंबर 5.
Yes, that's I have no objection in that regard.
Then what?
But they are obstructing my portion of 229 road, and therefore I have.
They are. It is not your suit. If they are obstructing your portion of 229, you go and file a
I have
separate suit.
noticed me in that suit.
You go and file a separate suit for your right with respect to खाता number 229 प्लॉट नंबर 530. उनके सूट में आपको रिलीफ थोड़ी मिल जाएगा.
तो उनके सूट में हमको जो है
आपको इंजंक्शन दिया है कि उनके प्लॉट को आप डिस्टर्ब मत करो. बात खत्म. फिर क्या? इतना ही तो है हमको रिलीफ. इसके बियॉन्ड तो कोई रिलीफ नहीं दिया हमको. आपका क्लेम दूसरे प्रॉपर्टी पे था, उनका क्लेम दूसरे प्रॉपर्टी पे था.
Yes, that is there. I am not claiming their property.
हाँ, दूसरो. So what is your problem? बताइए. देखिए पेज नंबर 18 ट्रायल कोर्ट जजमेंट रनिंग पेज 18 में है
पेज 18
पैरा नंबर 11 के एंड में है
पैरालेल से कंटिन्यू रनिंग पेज 18
पेज 18
दैट हैज प्लेस्ड
पेज 18 में नीचे आइए after having recorded that both the parties are claiming different properties correct the court holds that the plaintiff has not been able to show his title over the property. However, the khatiyan which does not bear the name of the plaintiff and the receipts are not sufficient to show that the plaintiff's legal right over the property in dispute. जब डिफेंडेंट ने प्लेंटिफ का प्रॉपर्टी को डिस्प्यूट ही नहीं किया, डिफेंडेंट ने अपना अलग प्रॉपर्टी डिटेल बताया.
ये प्लेंटिफ को करें ना कुछ प्रूफ नहीं किया. प्लेंटिफ हैज नॉट प्रूव्ड.
has not proved whatever. This
This
was the finding.
I am defendant. Plaintiff
You are
has
the
not-
defendant.
Yes.
So the finding against the plaintiff was that although the description of property for the plaintiff and the defendant are different, but the plaintiff has not proved his
able
title.
to prove his case, my lord.
Prove his title.
His title. Yes.
He was seeking injunction. It was not a title suit. He was seeking
It was seeking
injunction
permanent injunction against me.
against you. And when you appeared, you said that your property is different and the property of the plaintiff is different.
Different.
There was no dispute with regard to the title of the plaintiff. There was no dispute
There is no
from your
dispute regarding
side.
title. It is not under my title. It is not their title.
No, you are not supposed to dispute their title
I am not supposed.
because you are not claiming that property. As per description of your property,
yes.
it was different from that of the
Different
plaintiff.
from that property.
Okay,
But
that is why the plaintiff had filed the suit, filed the appeal.
But why against me, my lord?
Because you are the party. That is why it has.
I was not party, my lord.
You are party in the
Initially-
suit.
initially I
अपील
was
आपको बिना पार्टी बनाए कौन से लॉ में अपील फाइल कर
आई
देंगे?
अपील नहीं हो, सूट में हम पार्टी बना, सूट में हमको बनाए.
सूट में आपको बनाए
जी.
हैं.
अपील तो हो गया, जब सूट में बना देंगे तो आगे हम यहाँ भी आना पड़ा.
तो सूट में तो बोल दिया कि डिफेंडेंट का प्रॉपर्टी अलग है, प्लेंटिफ का प्रॉपर्टी अलग है. ठीक है, लेकिन फिर प्लेंटिफ के लिए बोल दिया कि उन्होंने अपना टाइटल नहीं प्रूव
He
किया.
was seeking injunction against me.
But you never had a title over the property.
No, that property was not. Never mind. I was a lessee of khata number 229, which was a couple post construction that has been demolished during last 5 years, and they are trying to grab that portion on which I am on lease. And therefore,
आप अपना सूट फाइल करके उनको ग्रैबिंग से रोकिए. है ना?
तो इसको लिबर्टी दे दिया जाता.
वो लिबर्टी तो आपके पास इतना है कि कुछ कहने का नहीं. हम लिबर्टी देकर आपको कन्फाइन नहीं करना चाहते.
हाईकोर्ट तक मैटर आ गया. लिबर्टी तो
हाईकोर्ट तक
थोड़ा सा
सुप्रीम कोर्ट तक आएगा, आपको क्या लगता है?
मैंने कोर्ट बिलो में तो कुछ सुनवाई ही नहीं.
वही हम समझने का
Demarcation
कोशिश कर रहे हैं कि आप लोग का लड़ाई हुआ किस लिए.
लड़ाई हुआ, बस हमको पार्टी बना दी, हमारा जमीन बस लेना चाह रहे हैं, और कोई लड़ाई ही नहीं था. सूट में I have been made party in the suit, and I have been noticed. And not only that, these two persons, they are stranger, Vicky and Sonu, who are defendant before the suit for the trial court. They are nowhere in the picture. These two have also been made party to that suit, and therefore issue number 4 has been formed. Non-joiner and misjoiner of the parties के लिए, and that has not been decided by the appellate court.
heard the learned counsel appearing on behalf of the applicants. That's specifically for This appeal has been filed against the judgment dated 16/1/2023, passed by learned, and decree dated 25/1/2023, passed by learned District Judge Roman 4, East Singhbum at Jamshedpur in Civil Appeal number 58 of 2019. Whereby the appeal has been allowed. The trial court judgment and decree is dated 12/7/2019 and 19/7/2019 respectively, passed by learned civil judge within bracket junior division bracket close East Singhbum at Jamshedpur, entitled suit number 76 of 2001, whereby the learned trial court had dismissed the suit. The suit was filed for injunction restraining the defendants from disturbing the peaceful and uninterrupted possession of the scheduled property of the plaintiff. The learned counsel for the appellant, while referring to the judgments passed by both the court, has submitted that the trial court had dismissed the suit by referring to the fact that the plaintiff was seeking injunction for plot number 532, khata number 127, and defendant was claiming right over plot number 229 of khata number 532.
Khata number 229.
Sorry?
Khata number 229. plot number-
खाता नंबर 229 प्लॉट नंबर 532. ये इसमें गलत लिखा हुआ है ऑर्डर में. प्लॉट दोनों का सेम है ना 532.
प्लॉट इसमें 532 विद इन ब्रैकेट 1 कहीं आया है. प्लॉट सेम है.
खाता नंबर 532 क्या है? खाता नंबर है कि प्लॉट नंबर?
प्लॉट नंबर खाता नंबर 127 एंड 229.
ठीक है. Plaintiff was claiming खाता नंबर 127, प्लॉट नंबर 532, and defendant was claiming खाता नंबर
229.
229, plot number 532. And the learned trial court was of the view that there was no overlapping interest or clash of interest with respect to the suit property, as both the parties were claiming different properties altogether. The learned counsel has further submitted that in spite of the fact that the plaintiff and the defendant were claiming different properties, the appellate court has passed an order of injunction against the defendant and has reversed the judgment passed by the learned trial court. The learned counsel has reiterated that the plaintiff was and that the defendant is only concerned with khata number 229 and has no concern with khata number 127. After hearing the learned counsel for the parties, this court finds that the plaintiff was claiming the property being khata number 532, being khata number 127, plot number 532, by virtue of registered sale deed bearing number 2285 dated 17/6/1996. And on the other hand, the defendant was claiming another property in khata number 229, plot number 532, by virtue of a lease deed. Lease था ना आपके फेवर?
Lease था.
By virtue of a lease deed. It was the case of the plaintiff that the plaintiff wanted to construct a khapra posh house over his property, and the defendant has been harassing the plaintiff and obstructing the construction. And the plaintiff had also had also given in writing to the officer in charge of Duxalai police station against the defendant on 6/6/2013, but no action was taken. And ultimately the plaintiff filed a suit. From the records of this case, and further it is not in dispute that the learned trial court has recorded that the plaintiff was claiming plot number 532, khata number 127, and also claimed that the defendants were obstructing the peaceful possession of the plaintiff over the suit property. And on the other hand, the defendant was claiming khata number 229, plot number 532, which was leased out to the defendant for a yearly rent by one Durga Sardar. The learned trial court recorded that both the parties filed their documents with their respective plots, and that there was no confusion, and ultimately recorded that there does not seem to be any overlapping interest or clash of interest in the suit. With respect to grant of injunction on plot khata number 127, plot number 532, the right of the plaintiff was not disputed by the defendants. However, the learned trial court went ahead to note that the plaintiff had to show their legal right over the property, and the plaintiff had exhibited the khatiyan, which has the name of the owner from which the plaintiff bought the suit property and municipal receipts. However, the khatiyan did not bear the name of the plaintiff, and the receipts were not sufficient to show that the plaintiff's legal right over the property, and ultimately held that the plaintiff has not able to prove his right, and therefore there can be no violation of such right, when from the perusal of the evidence there was no overlapping interest between the plaintiff and the defendant, and there seemed no threat from the defendant, and ultimately dismissed the suit. The learned appellate court considered the materials on record and found that the plaintiff was claiming title over the suit property by virtue of a registered sale deed dated 17/6/1996. Executed by registered sale deed dated 17/6/1996, executed by the son, namely Raj Kishore, बस deed का date ही दीजिएगा. Registered sale deed dated 17/6/1996, and ultimately recorded that both the parties were fighting for different property details and were two different plots, and none of them claimed that both the plots are one and the same, and both the parties have filed their own documents relating to the respective plots. The learned appellate court also recorded that the plaintiff had filed a copy of the Khatiyan which showed that the land is recorded in the name of Kamla Devi by Khata number 127, plot number 532 at Sikmi Dakhaldar, and he claims over the suit land on the basis of registered sale deed Exhibit 3, which was also mentioned. And after purchase of the suit land, the plaintiff used to pay municipal taxes by Exhibit 2 and 2 by B. The right of the plaintiff was over the suit property was disputed by the defendant by arguing that the Sikmidar has no right to transfer the land because Sikmi land is not heritable. The learned court ultimately primarily on the basis of registered sale deed in favor of the plaintiff, and also recorded that the defendant/respondent had also challenged in the written statement that Rajkishore Prasad, the vendor of the plaintiff, was not the son of Kamla Devi but had not produced any documents in that regard. The learned court ultimately recorded the following finding and granted injunction in favor of the plaintiff. यहाँ पर पेज नंबर 37 में इसको कोट करना है. This court finds that although the interviewed judgment of the first appellate court is a judgment of reversal, but the learned first appellate court has rightly considered the materials on record, particularly the fact that the plaintiff was claiming title over the property by virtue of a registered sale deed, and also the fact that the defendant and the plaintiff were claiming two different properties and there was no overlap. And therefore, the learned first appellate court held that the obstruction created by the defendant number 1 to cause damage to the plaintiff cannot be and ultimately passed an order of injunction, permanent injunction against the defendant. It is not in dispute during the course of arguments of the appellant defendant that the defendant has got nothing to do with Khata number 127, plot number 532, and defendant has claim only over Khata number 229, plot number 532. The suit property claimed by the plaintiff and the property claimed by the defendant are two distinct properties. Considering the judgments passed by the learned First Appellate Court and the case of the respective parties, this court finds that no substantial question of law is involved, and accordingly this appeal is hereby dismissed.
Since the plot number is 532, both the plot number is 532. So they are adjacent. Problem here.
आपको अपना सूट फाइल करना पड़ेगा. आपको अपना सूट कि आपका जो घर बना हुआ है वो कहाँ बना हुआ है
कुछ लिखवा दिया जाता है
उतना नहीं.
तो
वो आप गलत फोरम में 2001 से लड़ रहे हैं बिना कारण. आप अपना सूट फाइल करके डिक्लेयर करा लीजिए अपना टाइटल with respect to the constructed property.
Even on behalf on basis of my application, demarcation is not being made only because of this case.
उसके लिए रीट में हम बैठेंगे तो हम तो तुरंत ऑर्डर कर देते हैं but demarcation.
Only because of this case,
नहीं
demarcation
yes.
is not being.
नहीं not because of this case.
Since this case was running from that time, my application for
आज आप
demarcation is not being.
देखिए अब तो क्लियर हो गया कि आपका प्रॉपर्टी अलग है और उसका प्रॉपर्टी अलग है. एकदम हम क्लियर लिखा दिए. अब आपको डिमार्केशन कराना है कि कौन सा प्लॉट नंबर कहाँ पर है, आप डिमार्केशन करा लीजिए, है ना. हम तो यहाँ से तुरंत कर देते हैं डिमार्केशन का ऑर्डर. दैट डज नॉट क्रिएट एनी राइट टाइटल इंटरेस्ट एंड पोजीशन इन फेवर ऑफ वन और द अदर पार्टी. अगर सूट में जाके हर एक का डिमार्केशन अगर होने लग जाए और अगर हम डायरेक्ट नहीं ऑर्डर करें तो कितना सूट फाइल होगा आप समझ ही सकते हैं.
Orders.
सर्कल ऑफिसर कर देते हैं डिमार्केशन, हमको कोई
नहीं कर रहे इसलिए हमको करना पड़ रहा है.
कर देंगे.
कोई केस ही नहीं था यहाँ
कोई
से
जरूरत
करना
नहीं
होता
है, कोई केस ही नहीं था अननेसेसरी.
तो नहीं कर रहे इसलिए हमको यहाँ आना पड़ा.
Orders item 6, second appeal 78 of 2020.
There is a limit application for condemnation of delay of 21 days. Notices were issued on the limitation petition.
We are here for one of the respondent. Respondent number 1.
Who is respondent number 1?
Respondent number 1.
Respondent number 1 is the contesting party, Your Lordship. Others
What
are
about
performer.
others?
Others are performer respondent, Your Lordship. We have mentioned. Page number 3, Your Lordship.
So why are they not appearing?
In
If
fact,
they are your parties, they should be appearing.
they were performer defendant in the suit as well, Your Lordship.
They never contested the suit. Received by uncle, received by brother, क्या करेंगे इसमें? This is under order 41 rule 11.
No, for
Orders.
orders, Your Lordship. Condemnation application.
Is it a partition suit?
No, it was for declaration of right.
Respond number 6, 7, 8, 3, 4 and 5 have expired. They are performer defendant.
They are performer defendant.
तो उसके लिए तो आपको कुछ करना तो पड़ेगा ना.
Will take steps for substitution.
Essay number 78 of 2020. As per office note, respondent number 3, 4 and 5 have expired. So far as service of notice upon respondent number 2, 6, 7 and 8 are concerned, the counsel for the appellant has submitted that the notice has been received by either by themselves or by close family members, and submits that the notice be accepted as validly served. Any objection? The learned counsel for the respond number 1, contesting respond number 1 has no objection to the prayer made. Accordingly, the notice upon respondent number 2, 6, 7 and 8 is accepted as validly served. since respondent number 3, 4 and 5 are reported dead, counsel for the appellant prays for damage. That I take.
3 weeks, Your Lordship.
Prays for 3 weeks time. Post on 17th of June.
Item 7, second bill 75 of 2022.
Your Lordship, this is IS for substitution of one of the respondents, Your Lordship.
Which respondents? Notice has been issued.
No, Your Lordship, this is still under hearing under 41.
No notice for substitution.
No, Your Lordship.
देखिए IA number 4742 of 2025. Counsel for the appellant has submitted that respondent number 3, namely Shri Chandrasekhar Prasad, has expired on 24 to 2025. The details of the legal heirs and successors have been mentioned in paragraph 5 of the interlocutory application. Let notice be issued to the proposed legal heirs and successors of respondent number 3. It is an admitted appeal.
No, Your Lordship.
Petition for condonation of delay.
No, Your Lordship.
It is not delayed.
No, Your Lordship. He died on 25th February.
Requisites under ordinary process. कहाँ के हैं? लोकल? झारखंड? नहीं नहीं, सब ऑर्डिनरी प्रोसेस तो कैसे जाए? छत्तीसगढ़ में।
बिहार के लिए। Your Lordship, just wanted to point out, Your Lordship, since notices has not been issued to any of the respondents, since it has not been admitted, it requires.
Yes. Notice to the proposed legal heirs and successors, as mentioned in paragraph 5 within bracket Roman 1, Roman 2, Roman 3, Roman 4 under ordinary process, and Roman 5 and 6 through speed post, for which requisites be filed within a period of 10 days from today. Let notice be also issued to the respondents in this appeal. Respondent number 1, 2. कितने respondents हैं भाई? To all the respondents in this appeal, in the interlocutory application, being IA number 4742 of 2025. सब आप ही के हैं, प्रो फॉर्मा लग रहे हैं सब।
Yes, Your Lordship.
नहीं अपियर होंगे तो एडमिट अगर हो गया तो दोबारा नोटिस करना पड़ेगा। सब लोकल हैं, बाहर के?
ये लोग सब लोकल हैं, Your Lordship. सब लातेहार।
Requisites under ordinary process. ये भी हो जाएगा 10 दिन में?
Yes, Your Lordship.
10 days. Post on 2nd of July. Awaiting service. आप इनकी तरफ से counsel for the state.
Item 8, first appeal 239 of 2024.
Yes. Your Lordship, this case notices were issued on 6/1/25. Respondent number 1 is appearing, Your Lordship. This is admitted case.
Respondent number?
1 is appearing, Your Lordship.
So, what about others?
They are not appearing.
You have seen the office note?
Yes.
What is the office note?
Respondent number 2, 7, 9, 11, 13, 19 and 20 and 25 received the notice.
बहुत लोगों का तो एहसान नहीं आया है। Respondent number 10 has appeared only. One तो नहीं appear हुआ. How do you say respondent number 1 has appeared?
I have seen in the status.
Status में देख रहे हैं, ऑफिस नोट नहीं देख रहे हैं. चलिए. FA number 239 of 2024. Learned Counsel for the Appellant seeks adjournment to go through the office note. Post on 2nd of July. Let me check office note back to file.
Passover case item 18, second appeal 11 of 2023.
Yes, Your Lordship, I'll be either next week.
Passover क्यों मांगा? Second appeal है.
Only not today, Your Lordship, then it would automatically be there in the.
Second appeal number 11 of 2023. The
Monday
Learned
itself,
Counsel for the Appellant
I started, but I did not get the
Six.
file yet.
adjournment. He submits that he is not ready with the brief today. On earlier occasions also, the matter was adjourned to enable the Learned Counsel for the appellant to get ready in the brief. Since the appellant is again seeking adjournment, post this case on 2nd of January 26.
Your Lordship had asked me to point out if there was any, there's one case which is in serial number 24. It is related to Santhal daughter's right to inherit the property. So that would be an important, if Your Lordship would
कहाँ
take
है
it up.
serial number कौन सा?
Serial 24.
Can you respondent कौन है?
So we only start and then.
कौन है 24 को? Other side कौन है? बाकी लोग तो हैं नहीं. अच्छा कॉल करते हैं मुझे.
ठीक
थोड़ा देर रुकिए.
ठीक है.
कॉल करिए तो नेक्स्ट केस जो रेगुलर कोर्स में जो केसेस को अलाउ करते हैं वो कॉल करते हैं.
For hearing item 20, first appeal 201 of 2015.
I said yesterday claim for adjournment in this.
Adjournment request. यहाँ तो adjournment request है और execution में क्या है? वहाँ भी adjournment request है. यहाँ पे adjournment ले रहे हैं, execution आपका 2016 से चल रहा है. बताइए. I will observe that there is no stay. कितना टाइम चाहिए आपको?
4 week का टाइम भी कुछ
4 week टाइम दे दे रहे हैं. बस there is no stay of execution. सुप्रीम कोर्ट का ऑर्डर आ गया ना 6 महीना में एग्जीक्यूशन केस डिसाइड करना है. कोई बात नहीं. आप तो तैयार ही नहीं है. फाइनल हियरिंग के लिए मैटर लगा हुआ, आप क्या एग्जीक्यूशन केस का स्टे हम बहस करेंगे. हाँ तो फिर you are not ready with the matter. The case is fixed for final hearing. FA number 201 of 2015. The case is ready for hearing. However, the counsel for the appellant seeks adjournment. On 18/11/24, the matter was adjourned by way of last chance. Counsel for the appellant has submitted that he has circulated advance notice seeking adjournment. क्या सूट था? सूट was for?
Earlier the participant suit has been filed by the mother and one of the daughter. And thereafter
The कब चाहिए आपको?
after 4 weeks.
The counsel for the appellant has prayed for 4 weeks adjournment. Was this case on 18th of June? It is made clear that there is no stay of execution notice. Being execution case number 28 of 2016, said to be pending before the Court of Learned Civil Judge, Senior Division Court, Alma.
Item 21, second appeal 192 of 2016.
4 weeks. 4 weeks.
Question of law कहाँ है? Where is the question of law?
9/5/2024 order.
Specific performance में इतना time हम नहीं दे सकते. वो रिस्क. I'll not give you so much. और ये 2016 से चल रहा है, इसका क्या करेंगे? Yes.
After vacation मेरी डेट थी.
कौन सा वेकेशन? 26, 27,
नहीं
28
नहीं 24
सब्स्टिट्यूशन फाइल करना है.
नहीं 24
You are the plaintiff or the defendant?
plaintiff
Plaintiff टाइम मांग रहा है. Specific performance of contract. तो आराम से आपको 2-3 साल का इंटरव्यू दे देता है. हाँ, you are the defendant.
Milord, very short issue involved now, Milord. In fact, since I could not assist this honorable court at the time of framing of those question of law, Milord, what has happened, the trial court just said they allowed his alternative prayer. He made 2 foot prayer. First was
45,000
specific,
refund का.
the second was refund. So they only allowed for refund. Now the point is, my lord, he never preferred, the appellant, current appellant never preferred a cross appeal against that order. I preferred an appeal before the district judge. So the
Questioning the refund.
yeah, questioning the refund. So that was my appeal was allowed, and against that appeal,
इतना टाइम नहीं देंगे. कल तैयार हो जाइए.
my appeal was allowed, and now
इतना टाइम हम आपको नहीं देंगे.
question is only of that
कुछ नहीं आपको
40,000.
कल
नहीं 2 week comes
फाइल खुली, जजमेंट पढ़ी.
2 week
अब 2 मिनट का भी एडजमेंट नहीं है. पढ़ी.
2 week जरूरी
क्या चीज़ जरूरी है? कोई चीज़ जरूरी नहीं है. नहीं देंगे इतना लंबा एडजमेंट. स्पेसिफिक परफॉर्मेंस में इतना लंबा एडजमेंट नहीं होता. परसों पढ़ लीजिए. परसों पढ़. ऐसे नंबर 192 of 2016. Counsel for the parties are present. The case arises out of a suit seeking specific performance of contract. Pose this case day after tomorrow under the heading for final decision.
नेक्स्ट वीक करें क्योंकि पर्सनल डिफिकल्टी क्लाइंट इसीलिए तो
क्लाइंट को कोई पर्सनल डिफिकल्टी होता है क्या? रिकॉर्ड है, पर्सनल डिफिकल्टी क्लाइंट का क्या हो सकता है?
वो क्लाइंट का कहना है कि हम इसीलिए
ऑनलाइन सब लोग ज्वाइन कर सकते हैं।
नहीं हॉस्पिटल में है ना
इसीलिए तो ज़्यादा जरूरी है अभी कर देना, सब्स्टिट्यूशन फाइल हो जाएगा ज़्यादा दिक्कत है।
ले
नहीं, इतना लंबा टाइम नहीं देना।
Item 22,
आज
second
हम
appeal
सुन चुके
298
हैं।
of
ये तो नेक्स्ट
2016.
वीक कर दिया इसको नेक्स्ट
Tuesday. Final disposal in supplementary costs. Yes, please. Who is appearing in this case? This is serial number?
22.
हाँ बताइए। इसमें क्वेश्चन ऑफ लॉ कहाँ है? इसमें कोई आईए भी पेंडिंग है? आईए भी फाइल है इसमें? Learned counsel for the appellant seeks some time to file interlocutory application for rectification of substantial question of law.
नहीं वो सब हो गया।
अच्छा, उसके बाद फ्रेश बन गया।
ये जो है ना उसमें थोड़ा सा एक एरर था जस्ट सब सॉर्ट ऑफ क्लरिकल है व्हिच हैज ऑलरेडी बीन क्लैरिफाइड। दो पॉइंट ऑफ लॉ है इसमें। पहला पॉइंट ऑफ लॉ ये ऑर्डर डेटेड 31st ऑफ
पहले सब्सटेंशियल क्वेश्चन ऑफ लॉ देखते हैं।
हां
कौन सा ऑर्डर पढ़े?
31/3/2022 को
31/3/2022।
with the courts below did
हाँ।
where the courts below have failed to take into consideration the title of the appellant in view of the exhibit 4 and 5, read with findings of the first appellate court that hukumnama which is issued in favor of predecessor in interest of the appellant was not paid. Second, whether in view of the specific finding of the first appellate court that the land has been settled in favor of ex-landlord to predecessor in interest of this appellant by hukumnama, impugn judgment could have been passed. इसको जो करेक्ट किया गया कि whether in view of the specific findings of the first appellate court that the land was settled by ex-landlord in favor of predecessor. The appellant's interest of the appellant by hukumnama impugn order to be passed. These are the two points. Lord,
You are the
I am the plaintiff.
concurrent findings.
Concurrent. The land in question is my lord.
बताइए।
Yes. Land in question, your worship, is three tracts and some land source. Your worship may kindly have a look on the plate.
Should I see from the plate or the impugn judgment will be sufficient? Do we need to look at the plate?
Yes, your worship may kindly see the decree.
Trial court decree?
No, try.
Yes.
It is 4.59 acres total. Lot number 223, 224, lot 78 and 79, 1.3 acres, Bodia Aji, Nukan Bar, and 0.71, 008, 4.25, 4.9.
Schedule A.
This is the land and which includes
Only one schedule?
Yes, only one. A and B, there are 2 parts.
That's an N.
A and B, there are 2 parts. In A, my lord will find there are ones, and B, it is land of खाता number 20.
नूतन बान और ये है गोराई.
गोरिया
ये क्या?
आर में बान.
बान. ठीक है.
Our contention is that these all lands, including this land as well as marks, it was settled by virtue of Hukumnama, and we are claiming it that after the vesting, it did not vest in the government. It is our land, and the claim of the
It was
government.
in Hukumnama in your favor,
My lord, Hukumnama is in my favor.
followed by rent receipt,
Yes.
delivery of possession,
Yes.
everything.
And not only that, there is a return filed by the Zamindar also.
In support of your claim.
Those are the exhibits which have been referred in the.
Is there any finding with regard to the returns?
Yes, those things are there. The learned trial court said that no, it is sort of a forged document, which means it's fake.
It's a forged
State
document.
was
Okay, return is a forged document.
No, Hukumnama.
Hukumnama is forged.
They were saying so. And thereafter, the appellate court has come out with a categorical finding that no, it is not a forgery.
But still, the appellate court did not decree
No,
also.
under the erroneous impression that the land is vested in the government. Once it is not. Section
There is a
4A
finding of the appellate court that so the appellate court has disturbed the finding of the learned trial court,
Yes.
although dismissed the
with
suit.
respect to Hukumnama.
Okay, let us see.
Though it has affirmed the ultimate finding it has affirmed.
That's right. Ultimate finding is what? That you don't have right over the property.
Yes, the learned
But with
appellate
respect to
court-
Hukumnama,
Yes.
your story has been accepted.
Yes, sir.
Where is that finding?
Yes, I am coming.
बताइए कहाँ है वो finding that Hukumnama is a genuine document?
Yes.
Oh, internal page 9.
The internal page 9 of appellate court.
Accordingly, I come to finding that though the plaintiffs acquired right, title and interest by virtue of Hukumnama,
Yes.
their right, title and interest ceased to exist after coming into force of Bihar
Yeah.
Land Reforms Act 1950.
Entry made in the revenue records of right as being Ghairabad, Mali, same as vested in the state. This what is the finding of the analysis. So, Lordship, prior to this page, you must kindly come.
What is the impact of this entry made in revenue survey record?
My lord, may kindly see page 8.
Page 8.
Your Lordship, may kindly see the last paragraph.
Yes.
Before Arun Chand Kumkha.
Yes.
Thus I differ
Yes.
with the finding of the learned court. I come to finding that the land in question was actually settled by ex-landlord in favor of the predecessor in interest by Hukumnama. However, the witnesses of the plaintiffs have admitted that the state government auctioned this property both oral and certain.
कब auction का कब का date है? Auction का date कब का है? What is the date of auction?
इनका बहुत बार ऑप्शन शुरुआत से भी
बिहार लैंड रिफॉर्म्स के बाद?
नहीं इधर था जब ये ऑप्शन
ये जो बोल रहे हैं कि स्टेट ने ऑप्शन कर दिया है।
स्टेट ने ऑप्शन किया है
कब?
2-3 बार किया है बता दूं।
कोई भी ऑप्शन पहले का है?
नहीं इससे पहले का
मतलब 1950 के पहले का है
ना
ऑप्शन?
बात 1950 के पहले का हो भी नहीं सकता क्योंकि
भाई क्या पता?
टाइम देयर वाज नो स्टेट
मतलब कभी लैंडलॉर्ड ने कोई डिफॉल्ट के कारण कुछ
ना
किया?
उसके वजह से नहीं इनका कहना ये है इस केस में कि ये एक्चुअली गवर्नमेंट ने बेस्ट कर दिया और इसका सराहत के लिए हमने इसमें नोटिफिकेशन बहुत बार ऑप्शन दिया है कुछ लोगों को सेटलमेंट भी किया था उसको भी हमने पार्टी में
तो सैरात के लिए बोलते होंगे बिहार लैंड रिफॉर्म्स में स्पेसिफिक प्रोविजन
सराहत कैन नॉट बी सेटल्ड टू द
लेकिन ऑलरेडी सेटलमेंट है तो
उसके बावजूद भी बोलते हैं दैट इज बेस्ट सो फॉर सराहत
ऐसा कोई लॉ है?
ऐसा लेकिन इसमें एक glitch that if the settlement has been made for agricultural purpose एग्रीकल्चरल पर्पस के लिए अगर वो सेटलमेंट, देन दैट विल काउंट।
इसमें सेटलमेंट बस फॉर
यस, हमने प्लेन्स में ये चीज प्लीट किया, हमने एविडेंस भी लाया। तो ये इस नेचर ऑफ सेटलमेंट जो है इट इज फॉर द एग्रीकल्चरल, और उस टैक्स से अगर आप इरिगेशन के पर्पस के लिए अगर आप उसको
then it will not
then
vest.
it will not.
मतलब you will have the exclusive right.
I have a right.
Exclusive.
Exclusive.
ये आप कहाँ से बोल रहे हैं? कोई जजमेंट है?
There are several judgments.
बताइए, एक भी जजमेंट बताइए। एक ही जजमेंट बहुत होता है, सेवरल भी सेवरल। बिहार लैंड रिफॉर्म्स एक्ट।
पुराना जजमेंट मतलब पटना हाई कोर्ट में फर्स्ट अपील में कन्हैया सिंह एंड राम रतन सिंह।
साइटेशन क्या है? आप नोट करिए स्टेट।
हाँ
हाँ बताइए, साइटेशन बताइए।
ये साइटेशन 1964 रियल ग्राम पेज 66 रियल।
लाइए सर, मेरे लिए कॉपी लाए हैं।
पेज 66
मेरे लिए कॉपी लाए हैं।
काला।
हाँ दे देखिए, अभी 4:30 बज गया, कल सुनते हैं। सुन लिया आप इनका कहानी। एपेलेट कोर्ट का फाइंडिंग है कि हुक्मनामा वैलिड है, ठीक है, बट बिहार लैंड रिफॉर्म्स एक्ट में वेस्ट कर गया है, इसीलिए नहीं है। अब सैरात के बारे में इनका क्या डॉक्यूमेंट है आप देख लेंगे, और ये जजमेंट को एग्जामिन।
ये सिर्फ एक ही जजमेंट है जो रिलाइट कर
हमारा ही कहने लगे।
तो इतना तो फेयरनेस हम एक्सपेक्ट ही करते हैं मिस्टर शर्मा से।
लावण्या देवी बोल रहे हैं, लावण्या देवी जी अर्लियर गवर्नमेंट वाज आल्सो हर्ट।
बहुत बार आ
लावण्या देवी को केस बोल रहे हैं, हम उस पर रिलाई करेंगे।
हमारा इस केस में लागू नहीं होगा, आई विल शो।
ठीक है,
ये सुप्रीम कोर्ट का जजमेंट।
सुप्रीम कोर्ट
का इशू छोटा सा है, इशू तो लंबा चौड़ा नहीं है।
नहीं, लेकिन टैंक है, या दोनों सर्वे में सरकार का है रिकॉर्ड।
ठीक, देखते हैं।
टैंक है, एग्रीकल्चरल नहीं।
We'll see the finding, क्या फाइंडिंग है, और प्लेंट में कुछ बोले हैं वो एडमिटेड है क्या, इतना बार तो देखेंगे ना।
वो तो देखा टैंक है, ये एडमिटेड है, लगा हुआ।
एसए नंबर 298 ऑफ 2016।
साइड करेंगे ये भोला मियां का जजमेंट, इट्स एन ओल्ड जजमेंट ऑन द बिहार लैंड रिफॉर्म।
The learned counsel for the appellant has commenced his argument. As the court time is over, pose this case for further hearing.
कल पढ़ के आते हैं हम भी, और आप भी 2:15 बजे।
सीरियल 24
हाँ।
में
24 में कौन है?
सॉरी नहीं,
आप रेस्पोंडेंट है कि अपीलेंट?
हम appellate
तो ये चीज ठीक है, लाइए दिखाई 24। ये एक अच्छा जजमेंट
But today I am not a reading.
नहीं, कोई बात नहीं, लेकिन इसको करना है। ये राइट टू प्रॉपर्टी है, विमेंस राइट टू प्रॉपर्टी से रिलेटेड है ना, इसको करना है।
ये घर जमाई वाला
घर जमाई है, बट उसमें वो वाला भी बात आया है whether the daughter who is naturally also entitled or not, even if it is not established that it was in घर जमाई form, even otherwise whether she would be entitled.
कौन सा लॉ से गाइडेड है?
कस्टमरी लॉ।
हाँ ठीक है, कौन सा लॉ?
ये है गैंजर
संथाल।
सर्वे में there was a report, and in that report strangely all the courts have only taken note of the first portion of the where it has been mentioned that women do not have any right to inherit, but the subsequent portion of the same report, the J.F. Ganjar here also took note of the fact that now the law is changing now.
वो तो हम उस पे हम तो जजमेंट किए हैं।
हाँ, जो
एग्जैक्टली उसी पर, तो कहाँ है वो जजमेंट?
वो है हम खोज के रखें।
हम एग्जैक्टली उसी पर ही हम जजमेंट किए।
हाँ, तो उसमें but here your lordship this issue would arise that repeatedly this is troubling, so it has to be very clearly settled as to whether she gets a right directly even.
Because the shift in law,
Shift
in customary law was duly recorded in that
Yes.
survey,
and one Supreme Court judge.
and there is no son here. बेटा
no
नहीं है।
son.
ठीक।
Now the Agnet is claiming.
Agnet is claiming.
Yes, and
But he is having share in his ancestral land also. How can a Jamai can sell both?
No, we'll see
Once
that.
you are
Only
a
one-
We will
Kanja
see
man,
that. We'll see that.
One Supreme Court judgment, Lakshmi Bai versus Barman Guha, would be very relevant.
Okay.
It said that the customary law, whenever someone pleads, then he has to show that the customary law took the force of law and it was uniformly applied, as if it was a law. So if I'm able to show that it was not being uniformly applied, and as you
By virtue
pointed
of
out-
that survey.
Yes, yes. It would be by public, it was already changing. So if this was already noted, then it was not a binding law.
So therefore, it cannot be termed as custom,
Binding custom.
binding custom,
Yes, yes.
because customary law is something which has to be proved to the extent that it is being followed up to date.
Absolutely, and uniformly, as if it is a law.
Whenever there is any aberration,
Yes.
whenever there is any shift, so the rigors of it being a customary law breaks down,
Yes.
and the person who alleges custom has to prove it.
Yes.
So, इसको करते हैं, इसको हम लोग करेंगे.
but I would like to do it in
हाँ, नेक्स्ट कोई बात नहीं, आप नोट्स बनाइए, सुन लिए ना इनका इतना ही आदमी. लक्ष्मी बाई का जजमेंट ये आपको दे ही देंगे, आपको पता ही होगा.
एकदम I'll be only one paragraph, very clearly.
क्या साइटेशन है?
Lakshmi Bai versus Bhagwan Guha.
कोई साइटेशन है?
I'll give it.
आप हमको बताइए, ठीक है? और नोट्स बनाएंगे भैया आप लोग दोनों.
हम बनाएंगे.
ठीक है. Essay number 309 of 2016. The learned counsel for the parties are present. The counsel for the parties have submitted that important question of law arise in this case, which may have wide-ranging impact with respect to women's right to property under the community, namely Santhal. Both the councils have submitted that they shall prepare short synopsis of their arguments with supporting documents, supporting judgments which they seek to rely upon. They may also annex the various settlement report which has been referred to in the imprinter. जो इसमें है बस उतना है. ठीक है, जो इतना है.
May come out in 2 weeks.
क्यों 2 weeks? 2 weeks नहीं. इतना लंबा
Several exercises to be done. So many judgments.
अच्छा, आप लेके आइए ना, उसके बाद जब ये अपना आप थोड़ा देखिए. मैं आपको ये नहीं बोल रही हूँ कि आप कंप्लीट बनाइए, थोड़ा भी बनाइए. We can commence the hearing. And then आपको अगर एडिशनल कुछ देना हो तो कभी रोका है मैंने.
I have just for one more week. Nothing.
हाँ, that's वो उसमें कोई. Pose this case for final disposal on 6th of May. हो गया 2 हफ्ता complete. The synopsis of argument etc. should be filed by should be handed over to the learned court master by 5th of May.
This judgment
5
is
बजे तक.
2013, Volume 4 SCC, page 9,
2013
Volume 4 SCC,
SCC
page 97.
97. The counsel for the appellant has at this stage referred to the judgment passed by the Honorable Supreme Court reported in bracket 2013 bracket 4 SCC 97 and has submitted that the said judgment would be of relevance while deciding this case.